I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other Freedom of Information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition. And I want to thank you for joining us today for this webinar, which is part of our ongoing series on public records laws. And today we're going to focus on Maine public record appeals and learning how to fight back when your record request is denied. And I'm here with Sig Schutz, who's an attorney who's been a newsroom counsel to Maine's largest news organizations for more than 20 years. So Sig, thank you so much for joining us.
Thanks for having me, Emily, and thanks for doing this. And thanks for everything you do for the public's right to know and to keep the people informed about what government's up to. Well, let me take it in maybe two parts. And the first part is kind of the don't take no for an answer, what you might be able to do to push back without going to court or hiring a lawyer or representing yourself in court. And then the second part of our discussion can focus on how you can go to court and represent yourself. And in fact, I was just today reviewing a decision by someone I've been helping with questions here and there, but who's represented herself all the way through a final trial in Cumberland County Superior Court here in Portland, Maine, to seek access to information about the extent to which the county jail staff has been forced to work overtime. And she just prevailed and got an order requiring the county to disclose all kinds of compensation and related records, demonstrating the extent to which they've been forcing employees to work overtime, which obviously can be dangerous to the employees and create unsafe conditions at the jail. Real quick, some suggestions for steps that members of the public might take or journalists might take if you're denied access. And the first is don't accept the denial at face value. I would say there are certainly circumstances where the first response can be a no, but after further review and pressure, that can change either to a complete yes or to at least a partial disclosure of the types of information or records that you're interested in. Under the Maine Freedom of Access Act, a government has an obligation to cite a specific statutory basis for denial of access. So if there's a knee-jerk no at the counter at the town office, if the clerk says, no, I don't think that's a record, that's a record you're entitled to see. The question is, well, what statute are you relying on? What specific exemption allows you to withhold access to those records? Agencies in some instances will withhold an entire record, even when only some portion of the record is lawfully confidential. That's my third suggestion, which is ask the agency to redact and release, disclose the remaining portion of the record. Obviously, if you're concerned about the request, get the answer in writing. My fifth suggestion, the request can, in some instances, be elevated either to a supervisor, to a town manager, to somebody higher on the food chain, whatever governmental agency you're dealing with, or to their counsel. And if it's a state agency, that might be general counsel for the agency, that might be their contact at the Attorney General's office. And in some instances, the attorneys will set the agency straight, and that can result in additional access. With towns or municipalities or counties, other local governments, school districts, they typically do not have a lawyer on staff, and they may not have consulted with counsel before responding to your request. A lot of municipalities will rely on the Maine Municipal Association for advice and guidance on access, and they generally are a neutral umpire on this kind of thing. And sometimes you'll get a different answer than than the first one. And then my final point is just on meetings. The other piece of FOA, access to public meetings. Now look, if there's going to be a concern about a potentially illegal meeting, an executive session appears on the agenda for the meeting, figure out the law is up front and make your objections up front, and that can be successful. I've seen executive sessions scheduled be taken off the agenda or be made public after objections or after the governmental entity is consulted with counsel and gotten further guidance about the sort of the rules of the road on public access to public meetings. Let me see if I can bring up another some other sources of information that can be useful. This is the maine.gov/FOA website, hosted on the state's website. It's got links to a number of useful resources and guidance on public access in Maine. One of the resources is the Public Access Ombudsman. And it's not a page that contains a huge amount of information, but it does contain the contact information for Maine's Public Access Ombudsman, Brenda Kylty, who is in the Attorney General's office. She's an attorney, and part of her job description is to assist the public in obtaining access to records and information. So she's a resource to contact and involve if there's a denial of access. And sometimes she can successfully mediate disputes. And she's certainly a resource for additional questions and potentially pressure on an agency perhaps to reconsider their position. She doesn't have a history of, and I don't believe has issued any advisory opinions. She doesn't have enforcement authority. So, she's got a role to play and can be a useful and important resource. But the tools at her disposal to help the public get access are rather limited. The only governmental agencies in the state of Maine that are empowered to enforce the FOA, really, it's the Attorney General's office or the district attorneys. And they very rarely are willing to get involved in a request for records. Occasionally they'll intervene if there's something really egregious going on, but it is very unusual for them to take an interest in a particular request for records, even one that's clearly in the public interest. Really that leaves enforcement of the statute up to the public. And I'm just going to go back to the landing page for the Freedom of Access Act Right to Know page on the maine.gov website and click on Freedom of Access Act on the Maine State Legislature's website, which gives you a link to the actual statute itself, Title I, Chapter 13, Public Records and Proceedings, starting at Title I, Section 400, and then the last section is 414. But the section I think that we're focused on today is 409, appeals. The statute lays out definitions, what's a public record, the rules of the road on executive sessions, public notice. On records, the most important section is 408-A, public records available for inspection and copying, that contains the requirements for responding to requests, making records available, provisions on costs and so forth. But 409A is really where any member of the public needs to start in considering a potential legal claim or judicial relief where a request is denied. Section 410 violations, that exclusively deals with enforcement by the state. So that this is the remedies provided by Section 410, civil violation penalties. Those remedies are only available to the state of Maine. So those can only be pursued by the Attorney General's office or district attorney. But 409, which I was just mentioning, is the touchstone for claims, claims or lawsuits to enforce the public's right to know. And it's broken up into 4 subsections. 1 deals with records. 491 deals with records. 2, actions. That's essentially illegal executive sessions. That's the provision of the statute that allows challenges where a meeting is held in violation of the law, a secret meeting is held, a clandestine meeting. 3 just simply indicates that there may be other civil remedies under the law, and this isn't necessarily your exclusive remedy, but I'll say for all practical purposes, this is really the beginning and end of the likely remedies that any member of the public would want to pursue. The primary additional remedy would be some kind of a declaration by the court, what's called a declaratory judgment, some kind of statement by the court or judge as to what the law is. Usually that's not what we're after. We're after results, which is access. We want the info, not just a statement about what the law is. And then the final subsection deals with attorney's fees and the extent to which attorney's fees may or may not be available as a remedy in connection with a claim under the right to know law. So I'm just going to go back to the records section, section 1, and it provides for a 30-day deadline, 30 calendar day deadline after receipt of a written notice of denial for the filing of a lawsuit to enforce the right to know. So after a denial of a request, the requester has 30 days to file a lawsuit naming the agency or public official who denied the request and seeking relief. And that relief is spelled out here, an order for disclosure. That's the relief that the statute provides for, and that's really the primary relief that's at issue where you're dealing with records. The person's claiming that they were not they were denied access to the records. The denial is not for just and proper cause, and then the remedy available and sought under the statute is an order for disclosure. These types of claims it refers to appeals, but it's a civil action. It's a statutory civil action that's filed typically in state superior court. Each county in Maine has its own county seat, and that claim can be filed in the court where the requester lives, or in the court where the agency from which records have been sought has its principal place of business or headquarters. A lot of these cases are filed in Portland just because the large newspapers are based in Portland, or the state's largest newspaper. But a lot of them are also filed in Kennebec County, simply because that's where a lot of the state agencies are located. All the state agencies obviously are located in the state capital, Augusta, which is in Kennebec County. But the case, a FOA case, can be filed in any superior court in the state of Maine, and the person seeking to file a lawsuit would have to file the same procedures and processes that would apply to any civil action for any relief that's available from superior court. But this is really your touchstone and your starting point for what you would look at in filing a claim for access to records. Subsection 2 deals with executive sessions or meetings, public meetings, and the issue is the primary relief under this statute, if an illegal meeting has been held, is that any action taken at the meeting may be declared null and void. So a new contract is entered with the town manager in an executive session, that can be declared null and void, and the agency or the municipality can be required to do it all over again in a public session. I would recommend seeking other remedies like access to notes of a meeting, any notes taken by the persons present, perhaps an order requiring that minutes of the meeting be prepared or made available to the public. If the meeting was in any way recorded, that can also be made available to the public, assuming that an illegal meeting took place. But this is really your primary remedy by statute, is to have any action taken declared null and void. The issue is that the discussion that took place can't necessarily be, unless it was recorded, that can't be recreated for the public verbatim. But at least the action taken can be voided, and the agency can be forced to start over again from scratch at the beginning. I just mentioned the attorney's fees remedy. unfortunately, under Maine law, attorney's fees are only available if the agency is determined to have acted in bad faith. So if the denial of access to records was in bad faith, if the agency's decision to enter an executive session is determined to have been in bad faith, only then can the court award attorney's fees. And that makes for it a very high standard in recovering attorney's fees. In fact, I'm not aware of any case since that was added to the statute more than 10 years ago, where a judge in Maine has ordered that an agency pay the prevailing requesters legal fees. So the default has to be, going into any of these cases, these access cases, that win or lose, neither side is going to be paying the other side's legal fees. And even if the requester is successful, they're not going to be able to recover their fees. The final sentence just deals with federally recognized Indian tribes, and there is no attorney's fees or litigation costs available against them in the somewhat unusual circumstance where their meetings may be subject to the FOA. And most of what they do is not subject to FOA, but I'm not going to get into that right now. So what I would say, broadly, is there are some citizen guides available from the court on filing pro se litigation. If folks are in that position, you'd really look at the same guides that would apply to any kind of legal claim, whether it be to collect a debt, or for defective merchandise, or for denial of access to public records. You'd be filing a complaint, be paying the filing fee, getting a summons, having the summons served on the agency, and proceeding with the case. After a case, any FOA case or any civil case is filed in Maine, the courts will issue a standard scheduling order, and that'll set out all the normal case deadlines. What I would suggest for anyone concerned about access is very quickly at least write a letter, if not file a motion, asking the court to expedite the proceeding, and think about what evidence and information really needs to go in front of the judge to be able to make a informed decision about your right of access to these records. If it's a straightforward difference of opinion about the scope of a statute, that's usually pretty straightforward, and there's no need for a very lengthy legal proceeding and to invest an enormous amount of time and to wait an enormous amount of time for an answer. In some cases, there may be a need for some exchange of information, exchange of documents, or information to set a factual record for the judge to make a decision. And so I think, again, there's no one size fits all in these cases. A lot of the time, the records can be submitted for the judge to look at. We call it in camera or under seal in chambers, and then the judge would be able to make some judgment about whether the public agency or official is faithfully applying the statute to those records, or whether they're making an overbroad judgment as to what's public or not. In Maine, there are only two levels. There's Superior Court and the Maine Supreme Judicial Court. So any Superior Court decision can be appealed to the Maine Supreme Court. I don't know if we need to go into appeals today, but that's certainly a possibility. So you file a complaint, have a conference with the court, set a schedule, get a decision. The decision is favorable, or if you think there are grounds for appeal, you can take that appeal up to the Maine Supreme Court. And again, public records appeals are treated like any other appeal. The only thing I would suggest is if there is a real urgency to the matter, or some to make the clerk's office aware of that and to ask for the case to be expedited. And because the courts generally are sympathetic to the need for these cases to move at a faster pace than routine civil litigation. So that's the overview from my standpoint. Maine, unlike other states, doesn't have a FOA commission or administrative agency where you can take a public records or public meetings issue. Really, the only check on agencies that have denied requests is the judicial branch. is to take things to the judicial branch and bring things in front of a judge.
Gotcha. Thank you so much, Sig. Thanks for everybody who tuned in. And, be sure to check out NEFAC's website, where there's a lot more episodes about the public records laws all over New England. So thanks, everybody.